Welcome to Work This Way, a labor and employment podcast. I'm Tina Emerson, here today with Maynard Nexsen attorney Jenny Cluverius. Good to see you, Jenny.
Good to see you, Tina.
Well, with us today, we have another Maynard Nexsen lawyer, Andrew Kragie, who's joining us today from Raleigh to talk about political speech in the workplace. Thanks for being here, Andrew.
Good to be with y'all.
Great. Well, Andrew, employee speech has been in the news quite a bit after some have lost their jobs for commenting on the recent assassination of Charlie Kirk. And some employees are crying foul after termination. They're citing their First Amendment rights. Let's talk about how that argument might be flawed in certain circumstances.
Right. Well, most workers work for a private employer, a company, an organization, and not the government. And that means that the First Amendment doesn't apply in their workplace, because the text of the First Amendment says Congress shall make no law. It only limits the government. It doesn't limit a private employer from regulating or acting based on employees' speech generally. So the First Amendment for private employees has nothing to do with it. And actually, the First Amendment can protect the employer's right to act based on employees' speech or to put its own speech out there. So when people say First Amendment rights, maybe they're talking generally about free speech principles, but there's not a constitutional requirement for employers to allow free speech.
Andrew, the National Labor Relations Act is a law that many employers think only applies to workplaces that are unionized, which is a common misconception. That law does provide certain speech-related protections for certain employees, specifically supervisory employees in the workplace, especially the private workplace. Can you speak a little bit about how the NLRA affects workplace speech?
Absolutely. This is one of those big nationwide laws that affects all private employers, regardless, like you said, regardless of whether there's unions there, and actually regardless of whether there's even discussion of unionizing. There's protection for, it's called concerted activity, which is a sort of weird legal term from the 1930s that boils down to collective action or really any communication among employees about workplace conditions. But under interpretations of the past few decades, this can even cover when it's just one employee moving alone. Concerted no longer requires multiple employees together because the idea is, hey, maybe one employee is reaching out and trying to get some sort of concerted activity going. So there have been some cases like where the company announced a new policy for vacation time that one employee didn't like, and that employee replied all to the entire company and just ranted and raved, and it was pretty over the top and inappropriate. And I think there were some curse words, maybe some vaguely threatening language. And yet that was found to be concerted activity because it was about workplace conditions. Some scholars call this sort of the inverted First Amendment because generally the First Amendment blocks the government from intervening when you're speaking about matters of public concern. But this Section 7 of the National Labor Relations Act protects a lot of employees when they're speaking about matters of workplace concern. So it's sort of like it inverts the First Amendment so that employees have some protection potentially when they're talking about wages, working conditions, doing a salary survey. Maybe they would even be saying, we think our employer shouldn't fire people based on speech. That could be a concerted activity that an employer should watch out for.
What other federal laws are there that affect the employer's ability to discipline their employees for their speech?
Well, there are a couple angles to look for. One of them is that if you discipline some employees but not others, that could open you up to a discrimination claim. Even if there's not, that wasn't your motive. Somebody could say, well, you only fired this person when they spoke out with something you didn't like, but you didn't fire this person, and there's a difference based on, race, sex, sexual orientation, something like that. So that could lead to a Title VII discrimination claim, even if you have the right to fire them based on that, but saying that, hey, you didn't treat people the same. There are also a lot of anti-retaliation provisions sprinkled throughout different federal laws. So again, Title VII, the main law against discrimination in employment, has an anti-retaliation provision for either participation or opposition. So participation is things like, hey, I testified in this person's lawsuit against the company, or perhaps even things like, I talked with a government investigator for the Equal Employment Opportunity Commission. So you can't retaliate against that, which probably wouldn't be getting to political speech. Opposition can be a little trickier. That can be when somebody says, hey, employer, I think that you're treating people unequally and in some way discriminating. Even if they're wrong, if they have a reasonable basis to think that they're opposing illegal conduct, then that's protected and you can't retaliate for that kind of speech. And then a whole separate category is whistleblower protections. And this is something the Supreme Court has emphasized a lot recently in the past few decades under Chief Justice Roberts. There are like 25, 30 different statutes that have protections for whistleblowers. And that can be everything from occupational safety and health, mine safety, food and drug safety. There's really runs the gamut. And the thing here is that employees are only protected when they're speaking up through the right channels. So usually it does not protect, going to the media or posting on social media. Instead, it would protect reporting something to a regulator.
Andrew, we've talked about federal laws that impact employee speech rights in the workplace. We all know, of course, especially in the employment context, that many states will oftentimes implement their own laws that could impact these types of issues as well. Can you speak to us a little bit about what states are doing, if anything, from a legislative standpoint, or what they have done in the past that may impact the employee speech in the workplace issues?
Absolutely, Jenny. And you've dealt with this patchwork a lot, I know, and people should be talking with their lawyers about it because somewhere where around half of the states have their own protections that cover either some amount of speech or some amount of off-duty conduct generally. So some of the most protective states are California, which is, tends to be more protective of employees, Colorado, which is getting to a similar point, and New York. They broadly protect off-duty conduct and say that employers cannot discriminate based on lawful off-duty conduct. So that could include political speech. It could include going to protests. It could include saying things on social media. A lot of this depends on the specific cases that have been decided in the courts of those states. So it's not something where you can just Google it and take your best guess. If you have employees in those states, you want to make sure you're talking with your attorney about how to shape your policies and before you take any discipline based on off-duty conduct or speech. And then there's another wide range of states that forbid employment consequences for holding or expressing political views. So Utah and New Mexico have that formulation. And others protect political affiliation or political activity, but those might be more limited to actually like running for office or voting. So again, you just need to check for the states where you have your employees because the state law can be very tricky. And sometimes like South Carolina, Jenny, where you are, has a broad statute that says it protects political activity or political beliefs, but has been interpreted pretty narrowly.
Yes. So, and that's a good point, Andrew. It's some of these laws that we're finding that protect certain types of speech that employees may make are in states that you might not expect, like South Carolina. And the classic example that I usually give our clients is, you can't go out in your parking lot after an election and fire everyone who has a bumper sticker for the candidate that you opposed on the back of their car. That would be a classic example of, terminating folks in violation of at least our state statute. And I know Clemson's been in the news recently for, some statements that certain of its employees made that I think they were trying to assess, are these political in nature or not? And that was part of the reason for the delay in their decision. We'll talk a little bit more about public employers later. But you're right. Oftentimes you've got to check these state laws to try to determine if there's something else there beyond the federal law that protects what your employees are saying in and around and about the workplace.
And employers really like to keep this state of harmony in their places of employment. They want their employers to be happy, to be able to have conversations, to bring their whole selves to work and to be happy. But what are some really important considerations that employers have to think about and best practices when they're trying to balance this workplace harmony with employees that are expressing their political or personal views that may or may not be uncomfortable to their coworkers?
Absolutely. So our colleague David Smith in Alabama just published yesterday a piece on some considerations to think about before an employer disciplines based on, for example, social media posting that runs against company values. And one thing is, how much blowback is this going to provide internally when employees hear that a different employee was disciplined based on their speech? You might want to consider whether they were speaking in a purely personal capacity, maybe on a social media profile that doesn't mention their employer. And if that's the case, you could probably, depending on the state, still act if you want to. But you want to think about the internal ramifications on morale. And the best thing to do in advance, as our colleagues have recommended, is have a policy, whether it's on social media specifically or off-duty conduct or speech or political speech more generally. And we can help you craft those so that you don't need 20 policies on this one topic. But if you have a policy, you have to think about it in advance. You decide how much involved do we want to be in monitoring or reacting to employee speech. Because as we talked about earlier, there could be some risk if you discipline some employees but not others. There could be some morale concerns. And generally, if you have a policy that you fall back on that says maybe you decide that you're not going to discipline people based on, lawful off-duty speech unrelated to employment, for example, then that sort of simplifies your decision, and you can just say, this employee is not speaking for the company, but we don't discipline our employees based on their lawful off-duty speech unrelated to their employment, which this is. It's sort of like having a no comment policy. It's one thing if somebody a reporter calls you up and says, "What do you think about this?" And you just say no comment. It's easier to say, "We have a policy not to comment on this." And then people understand you're not just making a one-off decision. This is a well thought out approach. But Jenny, I was interested in hearing, in your experience, how do you talk with employers about this?
Sure. So one thing I think that comes up often in my practice is the issue of employees thinking that they can post anything they want on social media accounts without any consequence. And that, just because you're not in the workplace, just because you're not posting things on a company bulletin board or something along those lines, doesn't necessarily mean, especially with private employers and private employees, that they cannot be disciplined for that conduct. And it's interesting to me, with the rise of social media, how much of employees' conduct outside of the workplace is actually being brought to the attention of HR departments by usually their coworkers. And that brings us kind of full circle back to the earlier discussion about the National Labor Relations Act and protected concerted activity. If employees, say, are friends with employees on Instagram or TikTok or Snapchat or Facebook, whatever the social medium may be, if they are making comments about the workplace and they have coworkers interacting with them on that social media platform about whatever the comment may be, before an employer goes to terminate that employee, in addition to considering the very good employee morale concerns that Andrew was encouraging folks to weigh, you really need to also think about whether that employee is potentially engaged in protected concerted activity under the National Labor Relations Act. And again, a lot of employers, especially those who are not unionized, just do not have that front of mind. And they will proceed with the termination and then potentially draw an unfair labor practice charge because the employee's speech is actually protected concerted activity under that law. So very interesting how these issues arise in the workplace, and it is a very difficult path sometimes for employers to navigate from a legal standpoint.
And that's one thing employers in their policy might want to say up front if they do plan to be more involved, or if they are consumer facing and need to be sensitive to their consumer sentiment, trying to avoid a boycott or anything like that. Then maybe they put in their policy, we may act based on your outside speech because your reputation is our reputation. And then if an employee, protests, "Hey, why did you fire me?" and tries to sue over it and find some, route to say they were treated unequally, then the employer can say, "We told you up front, it's in our policy. We acted based on our policy. We've always treated everyone consistently."
Well, there are a lot of differences in the way that public companies and private entities operate. There are a lot of differences in the way that they're governed. As far as First Amendment rights go, how is that analysis different when we talk about what employees can and can't do and how they are told what they can and can't say?
So there are greater protections for employees and their speech in the workplace when you have a public employer as opposed to a private employer. And again, going back to what Andrew said earlier, the First Amendment is designed to protect against the government restricting speech. When you have a public employer, you basically have, in a sense, the government restricting speech in the event a public employer tries to limit what employees can discuss in the workplace. So there are greater protections, and the First Amendment does attach to employees who walk into a public workspace. However, those protections are not unlimited. Usually, in order to be protected, speech by a public employee has to be limited to their speech as private citizens on matters of public concern that do not disrupt their official duties in the workplace. So the first step in the analysis of is something protected speech in a public workplace is this employee acting in an official capacity as part of their job duties, which is not protected speech, or are they acting in their capacity as a private citizen, which on a matter of public concern, which could be protected speech in the workplace. Generally speaking, just personal workplace grievances are not protected speech for public employees. So if you pass that kind of test and the employee is speaking as an individual citizen about a matter of public concern in the workplace, then there is a balancing test that is employed to determine whether or not the employee's rights or right to free speech outweighs the government's interest in providing efficient public services. And there is a kind of seminal case on this topic, Pickering versus the Board of Education, that goes through the kind of how the balancing test works. Generally speaking, unprotected speech, as I mentioned, is made pursuant to the employee's official job duties. If it's purely a matter of workplace dissatisfaction, that's not going to be protected speech. If it violates ethics rules or like anti-harassment, anti-discrimination policies, that's not going to be protected speech even in the public setting. And importantly, for purposes of what's been going on a lot in the media and in workplaces lately, speech that disrupts the workplace or that causes or has the potential even to cause significant disruption to government operations, that speech is not going to be protected. So, someone speaking in a manner that a public employer feels perhaps is encouraging or inciting violence, that oftentimes is not going to be protected speech, even or especially, I should say, in a public workspace. So back to the Clemson comment earlier, there was a lot of controversy around some comments made by professors, I believe on their social media accounts, following Charlie Kirk's assassination. And there was criticism, I think, of the university for not moving quickly enough in taking action against the employees from a personnel standpoint. But I do think it's important for folks to understand that, especially for an employer like Clemson as a public university, there are certain things that have to be weighed and really carefully considered before you make the decision to terminate someone's employment, including this balancing test has to be employed. And then, of course, in South Carolina, as we've already talked about, there is the protection as to political speech. So it's not always the most straightforward or easiest assessment for employers to make. And I think that employers are well advised to seek legal counsel in situations where they have to terminate someone's employment based on, or they're faced with the decision of whether or not they should terminate someone's employment based on speech, whether inside or outside of the workplace.
And doing that due diligence has to happen in order to make the right call in the end, and taking that time.
It absolutely does.
And public employers, governmental employers, do have a bit of a leg up lately of the past couple decades as the case law has evolved, with what Jenny talked about of saying that if it's part of their job duties or related to it, that's government speech. It's no longer that person's speech as a private citizen. But something that people might not think about is exactly what speech is not protected under the First Amendment. And so people often think hate speech is not protected. But actually, the cases on First Amendment don't talk about hate speech as a category. People's unpleasant, offensive speech is still constitutionally protected. It has to cross the line that Jenny referenced about incitement to violence. And there's a test for incitement about whether it's actually imminent, whether it's actually likely. So people saying that praising violence in general, that might not cut it for a public employer. Of course, it really depends on the circumstances and on the exact words. And that's why you should talk to somebody who's dealt with this before.
Absolutely. Well, thank you both for the very timely discussion. It brings a lot of questions and a whole lot of interpretation. So thank you very much for the talk. It's a learning opportunity for employees and employers alike. So thank you both for being here, and we will see you next time on Work This Way.